Okay, I'm back. It was the December 21st, 2022 scheduling conference at 2:30 p.m. with Judge Mary Mahler, who is reassigned as the third judge in our case against Morrison County Sheriff's Department. Okay. After that hearing, she sent a notice of filing order. And this was the scheduling order. I'm going to read it to you, but it is here if you'd like to read it for yourself. The above entitled manner came on for a scheduling conference on December 21st, 2022, before Honorable Mary B. Mahler, Judge of District Court at the Morrison County Courthouse in Little Falls, Minnesota. Plaintiffs were physically present and are self-represented litigants. Attorney Julia Kelly of the law firm of Iverson Roovers appeared on behalf of defendant while preserving service of process objections. The court addressed questions raised by plaintiffs that were unrelated to the scheduling conference. The court, she's talking about when we asked about time sensitivity. Okay, remember that. Time sensitivity is what we were asking about. And she said it was unrelated to the scheduling conference. In our opinion, scheduling involves time. The court recognizes plaintiffs are self-represented litigants are entitled to represent themselves and bring claims before the judicial system. Well, yeah, of course we are. The court recognizes some individuals without the benefit of a legal education experience difficulty complying with the rules. So if we're not a lawyer, it's difficult for us to comply with rules. Well, if the rules were written where a normal person could read them and it wasn't misinterpreted by the courts in their own way to benefit them, then yes, we would be just fine. Any average citizen could be going through the courts. Okay. Equally, the court cautioned plaintiffs that it cannot provide legal advice to the plaintiffs going forward, such as service of process. Okay, so they're not going to give us legal advice. We knew that. We never asked them for any. Second, the court further cautioned that failure to comply with the Minnesota Rules of Civil Procedure, including discovery deadlines, isn't that time sensitivity? And the Minnesota Rules of Evidence could have significant consequences, including the dismissal of their action claims and an award of legal fees. So they're trying to threaten us again that they're going to charge us with legal fees and try to dismiss our case if we don't follow their timelines, their time-sensitive timelines on their scheduling order. Okay, thereafter the court inquired of each individual present if she had any further information to provide regarding scheduling. Plaintiff Lowgreen provided no additional information, but opined he would be pursuing default judgment with no opportunity to negotiate. Well, that's what we asked for the fourth time, was default judgment, and that's why we were supposed to be there that day, not for a scheduling conference. So Mike just reiterated that. Plaintiff Acker opined she needed a week to get her discovery together. No, I said I needed at least a week to get it in to them. Okay, she also sought confirmation the default motion was still set for February 22nd, 2023. Yes, the court advised the hearing was still on the court's calendar, but whether or not it remained on the calendar was dependent upon compliance with Minnesota Rules of Civil Procedure 4.03. That is service. Okay, Attorney Kelly requested the court reset a new scheduling conference since service of process has not yet been completed. Okay, people, tell me, if service was not completed, why do we have 89 documents on file? and we have a court file number, and we have the defendant who hired their own attorney who has attended all of the hearings so far. But they're saying that we did not service correctly. Still, okay? Amazing how they can do that. Attorney Kelly requested the court reschedule a new scheduling conference. Alternatively, she requested the opportunity to bring a motion to dismiss at the February 22nd hearing under the theory the plaintiffs failed to properly identify a legally recognized defendant. In the interest of judicial economy, the court treated the hearing as a scheduling conference and is setting the following deadlines. So for judicial economy, okay, but they keep going on with additional hearings and keep delaying things when they could have just entered the default judgment that we asked for 4 times before this. Okay, here's the scheduling order that she's trying to tell us. She was trying to tell us, and I say she was, so that you can watch future videos to find out what happened to Judge Mahler. Scheduling order. Trial date. This matter shall be set for a 1-day court trial on Tuesday, June 13th, 2023, beginning at 9 a.m. If either party wants a jury trial, they must file a written demand for a jury trial within 30 days of this order and pay the associated jury fee. Okay, we stated in the original complaint, July 28th, 2022, about 9 months ago, that we demand jury trial. Okay, now she's trying to tell us that we have to put it in writing again, which we did again because she told us to, so why not do everything that they tell us to do and then see how that goes. Number 2, pre-trial hearing. A pre-trial shall occur on May 25th at 3 o'clock via remote. The court will allocate 1 hour for the pretrial. Okay, people, remember, this whole case is about, we have 8 hours of videotape, plus we have over 150 violations that the Morrison County Sheriff's Department did, along with Pierce Police Department and the Minnesota State Troopers out of the Brainerd Division. Okay, so we have tons of evidence. Actually, we have 2 files of evidence. And it's ridiculous that we're going to take 1 hour to talk about all of our discovery. Okay. Number 3, service of process. Plaintiffs must effectuate service of process compliant with Minnesota's Rules of Civil Procedure 4.03 by January 20th, or their dispositive motion will be removed from the court's calendar. Well, guess what, people? We filed another amended complaint that returns back to the original complaint, started in July of 2022. And we serviced them correctly this time. However, we did service them through federal court this time. So we're moving it up a notch since they can't comply with their own rules. And we've already gone through 2 judges before this. We do not feel that we're getting a fair trial. Therefore, we are moving it to federal court. Number 4, discovery. Discovery shall be completed by April 1st, 2023. Witness exhibits list. All parties shall serve and file a list of witnesses and exhibits 2 weeks before the pretrial. 6, motions. Dispositive motions shall be filed and heard by the court at the hearing currently set for February 22nd, 2022 at 10 a.m. via remote. Non-dispositive motions shall be heard at the pretrial. Papers, pleadings, and hearings must be filed and served in accordance with Rule 115 of the Minnesota Rules of General Practice. Number 7, alternative dispute resolution. The parties shall comply with Rule 142 and Minnesota Rules of General Practice and submit to mediation by February 1st, 2023. Plaintiffs shall provide the names of 3 attorneys to serve as mediator. By March 1st, 2023, defendant shall select one of the 3 and contact the selected mediator to get it scheduled. Mediation costs will be equally divided between the parties. Mediation shall be completed by May 1st, 2023. All right, so alternative dispute resolution. She's demanding that we try to get 3 attorneys, and then the defendant gets to choose the one. And then we'll talk about any negotiations or mediation. No, not going to happen. And we'll tell you why in the following videos that it will not happen. And it did not happen. Number 8, decorum. Oh, listen to this. The court requires full compliance with the general rules of practice for the district courts by all attorneys and pro se litigants. Additionally, all attorneys and pro se litigants shall conduct themselves in accordance with the standards of integrity and courtesy expressed in the professional aspirations adopted by Minnesota Supreme Court. Okay, first of all, we're not in the Supreme Court, we're in district court, and they want us to comply with all the professional courtesy and have integrity and courtesy towards them, but they will have none towards us. And they're trying to hold us to these rules. Honorable. Mary B. Mahler. Mary B. Mahler, I just chuckled at you. I did not laugh. I chuckled at you. Okay, I'm going to stop this for right now, and then I'll go on to the next one.